keep you awake as much as possible about the very fascinating topic of legitimate interests. My name is Aurélie. Tomorrow I am sitting on a panel about the ethics advisory group of the EDPS, where we're sharing a very interesting report. So please join us for that. In the meantime, my background is in big data and digital analytics. So the reason why I'm interested in legitimate interests, which I consider to be a very barbaric name because I'm not a lawyer, is obviously because of e-privacy and how it's moving forward. But in the meantime, we would like to discuss this with respect to what it actually means, what you need to understand by it. And so I'm surrounded by smart people, smarter than me, that will explain their position. Everybody will have introduction remarks. And following that, we'll have a conversation also with you, I hope, and many questions related to that specific topic. So let me first of all introduce Raphaël Gellert, who is the chair of this panel. He is a postdoctoral researcher at Tilburg Institute for Law, Technology and Society of Tilburg University, obviously, and he is working on the ERC InfoLec project. He conducts interdisciplinary research, law and social sciences, and his PhD studied the risk-based approach to data protection. So let me leave you the floor. Thank you.
Okay, thank you, Aurélie, and hello, everybody. So yes, I will be chairing this panel, but I just nonetheless would like to make a few opening remarks about the relevance of this discussion on the ground of legitimate interest. So the bottom line for this panel is that indeed in the contemporary data-driven data processing environment with artificial intelligence and smart devices, it's becoming more and more difficult to rely upon consent as a ground for justifying and legitimizing the processing of data. So of course, the ground of legitimate interest seems like an appealing alternative. However, as we all know, it is still quite difficult to work it out in practice. And of course, there has been the opinion in 2014 of the Article 29 working group, who has clarified a number of elements, such as the fact that the legitimate interest must be explicit, clear, specific, and so on. But there are still a number of things that need to be clarified, and I guess this is what we'll try to be doing today. So just as a reminder and as a way to set the scene for everyone, so in order for this ground to be used, the data controller needs to identify legitimate interests, need to show that the processing is necessary for the completion of this legitimate interests, and importantly, this legitimate interest must not override the interests and fundamental rights of the data subjects concerned. So this leads us to a few questions that I think will be addressed during the panel. Well, the first question that we want to address is, so what is this legitimate interest? How can we measure this legitimate interest? Can we quantify it? What do we mean when we mean legitimate interests? Do we mean benefits? Do we mean benefits for the data controllers, for the data subjects, for society in general? So how do we do this? Then we also want to ask the question, so how do we actually do the balancing between the legitimate interest of the data controller and the interests of the data subjects? Can we rely upon ethical frameworks to do a solid balancing? There's also the issue of the burden of proof for data controllers. So how are they going to justify that their balancing exercise is a sound one and solid one? And then there's also the issue with data protection impact assessments, because we obviously see a lot of similarities in the sense that data protection impact assessments are also about balancing. It's also about the risks for the data subjects. Even though it's not clear in the GDPR, it's also about balancing the risks of the data subjects and the benefits for the data controller. So can we learn anything here? Can we try to integrate issues of legitimate interests within data protection impact assessment? Would that make sense? And we can also think in terms of measure and determination of interests, we can also think, for instance, of the guidelines of the Article 29 that were issued in October on data protection impact assessment, where they give criteria as to what qualifies as a high risk. So in this context, would that mean that when a high risk is identified, it automatically trumps the legitimate interests of the data controller? Can we use a similar mechanism in terms of two criteria or more to determine whether a legitimate interest of the data controller is sufficiently legitimate or not? So these are just opening statements that will pave the way, I think, to the discussion that we're going to have today. And with that being said, I think I will introduce to you our speakers. So we have, first we have Gabriela Zanfir Fortuna, who is currently EU Policy Counsel for the Future of Privacy Forum, and who is also an associated researcher with the LSTS Center at the VUB. We have also Leonardo Cervera Navas, if I pronounce correctly. Thank you. Who is the acting director of the Office of the European Data Protection Supervisor, which he joined in 2010, and he is responsible for the Secretariat for advising on law and policy. We have Dominique Hagenauw, who is principal legal consultant at Considerati, and who is also been senior international officer at the Dutch Data Protection Authority. Then we have Paul Breitbarth, who is Director of Strategic Research and Regulatory Outreach at Nymity. And he's working on Nimity's regulator project, which focus on demonstrating compliance to privacy and data protection law, and also on data protection process certification. And I think, Aurélie, you already introduced yourself, so I will leave it at that. So that being said, I leave the floor to Gabriela.
Thank you very much, Raphaël. Hello, everyone. Perhaps I should start by saying that my first participation at Cpdp was 5 years ago, and I actually presented my first big research paper. And the title of that research paper was Forgetting About Consent, why the focus should be on suitable safeguards in data protection law. So perhaps it fits well that now I'm talking about legitimate interest today. I will like to make 3 main points about using Article 6.1f, legitimate interests of the controller or a third party as a lawful ground for processing. The first point is that it's extremely easy for a business to have a legitimate interest in the sense of Article 6.1f. It really is. And if you look in the guidance of the Article 29 Working Party, the guidance from 2014, you'll see that the Working Party clearly states that a legitimate interest refers to any legitimate interest in any context. So, for instance, trying to identify a list of possible legitimate interests would not be it would be helpful, but I'm not sure how effective of an exercise, because the only condition to have a legitimate interest is to have an interest that is lawful, that does not go against the law. But now I go to my second point, and my second point is that even if it's very easy to have a legitimate interest, it's very, very difficult to be able to use that legitimate interest as a lawful ground for processing, because there are 2 additional conditions in order to be able to use it as a lawful ground. And those conditions are, necessity, which is often overlooked, but you'll see there in Article 6.1f that the data needs to be necessary for the legitimate interest of the controller or third party. And then, of course, there's the the second condition, and that is that balancing exercise, that is the fact that the legitimate interest of the controller or the third party must not override the rights, freedoms, interests even of the data subject. And this goes beyond the right to privacy, the right to data protection. It touches upon all rights of the data subject. So it's very easy to have a legitimate interest, very difficult to actually be able to lawfully rely on it, because there's also a lot of uncertainty with regard to how exactly should we make this balancing exercise, what exactly needs to be put in it. So my third point is that what controllers need, what businesses need most in this on this topic is helpful guidance on how to conduct this balancing exercise. What exactly do you put in the two plates at the end of the balance? And how to assess necessity. Again, necessity is equally important. I would add here, to be a bit helpful, that there are some indications in the recitals of the GDPR on what could be taken into account in the balancing exercise. So for instance, is there a direct relationship between the controller and the data subject? Is the data subject already a customer, or is there any relationship or nothing at all that could go into it? Then in terms of measures and safeguards that would rebalance an otherwise unbalanced comparison between the two. For that, we have some guidance in the Article 29 Working Party paper. So for instance, a very practical example is that if a controller allows for the right to data portability when data is being processed on the basis of legitimate interest, that counts toward rebalancing the otherwise unbalanced comparison. Because as we know, data portability is an obligation to be provided only when data is processed on the basis of consent or necessity to enter a contract. So that's something that the Article 29 Working Party mentions in their guidance. So I would stop here with the first remark.
Super, thank you very much. And I think maybe related to guidance or more official stances, we can maybe look at Leonardo to give us some of his points of view related to the subject.
Leonardo.
Thank you very much. I feel very honored talking today in front of all of you. I can see in the audience real experts of data protection, the privacy commissioner in Belgium, nonetheless. And I'm going to try to be very brief and a little bit entertaining because it's after lunch and we have to wake up a little bit. So I would like to kick off with an anecdote about this issue of the legitimate interest. When I joined the data protection unit of the Commission in 1999, long time ago, one of the first assignments that they gave me was to assess the transposition of the directive in Spain. So I did what Commission officials do. We started to do tables comparing the directive with the national law. And then suddenly I realized that famous Article 7F of the directive, the one on legitimate interest, was not in the Spanish law. So I told my Spanish counterparts, hey, I think you forgot one of the legitimate grounds for processing. And then they said, really? And they say, yeah, this is very important. And they say, we don't see it that way. We think that processing must be authorized by law and basta. And I said, no, sorry, the directive is very clear about this. There is law, consent, but there is also legitimate interest, so you have to do it. So after a while and some negotiations, they changed the law and they transposed this legitimate interest concept into Spanish law. This is just an example to illustrate that we have gone a long way on this idea of being flexible on the issue of processing personal data in the interest of companies. But this doesn't mean that these legitimate grounds for processing becomes an open door to do whatever a company may want to do with the data. So what I would like to do now in the next 2-3 minutes is just briefly to let you know, to summarize the position taken by the EDPS on this issue. We have scanned all the opinions and papers and debates we have had so far in the Article 29 Working Party about this point. And this is more or less the summary of what we've said about this. So the first point is that out of the 6 grounds for processing of personal data, there should be no doubt that consent is certainly more protective for the privacy of individuals. So in case of doubt, our recommendation is to go for consent. Not only because it's easier to withdraw, also because with the new data portability right, when processing is done on the basis of legitimate interest, you cannot take your data, but when it is done with consent, you could. So this is more beneficial for the data subject. The second point is that we believe that when a company is using this legal ground, should have the feeling of being entrusted with an extra responsibility. So it's like a kind of ethical sentiment that the company should have for the processing, and should take into account both the societal interest or the benefit for the individuals and the economic benefit for the company. Another point, which is I think is quite interesting, that we mentioned in one of our opinions, is that in those cases where companies feel really difficult to rely on consent and they decide to go for the legitimate interest ground, perhaps a well-designed and workable mechanism on opt-out is a very valid solution, because on this basis, those data subjects that suddenly feel uneasy, uncomfortable with the situation, can easily get away without necessarily objecting to the processing, which could be a little bit heavy. And the last point I would like to make, which links with the issue of ethics, that as you know, the EDPS is pushing on this ethical dimension. We strongly recommend companies basing their processing on this legal ground to have handy an ethical document, a value-driven description, which can then use very well to back up whatever justifications they can put forward in terms of legitimate interest. We believe that it is much more credible for a company to go about this processing if they have this document, which have thoroughly thought about the ethical dimension of the processing they are involved on. So this is my little contribution, Paul. I hope I didn't disappoint you, and I'm very grateful for your attention.
Thank you, Leonardo. I don't think we can disappoint Paul, and we're doing our best. So, but I would like to give the floor to Dominique as well, in terms of practitioner, maybe to give her thoughts about how it translates into practice. So the floor is yours.
Yeah, thank you for giving me the floor. I was indeed asked to say some words about legitimate interest from the practitioner's perspective. I work for Considerati, which is a legal consultancy firm in the Netherlands, and we provide advice on all kinds of data protection issues for both the private and the public sector. And that actually brings me to the first point, which I would like to raise, is that for the public sector, a lot has changed as well with regard to the use of legitimate interest, because the general data protection regulation does not allow the public sector to use it anymore. A lot of our clients actually find that difficult. While they try, of course, to base everything on the public task, there are, of course, sometimes processing operations that the law is not so clear about, for which they use the legitimate interest legal ground, which was possible for them until May 25th of this year. But they are now looking a lot into ways on how to cope with this gap that has arisen. As you may know as well, making laws is not as easy. It's not done in a limited period of time. So some of them are really in a squeeze at the moment on how they can do the tasks that they are required to do or asked to do without having a proper legal ground sometimes. I'm not sure if this is limited to the Netherlands. I suppose not, but this is something that we really see. And then another point, legitimate interest is a difficult topic for most organizations. Like the speakers before me also said, it's always difficult to make the clear balancing test. How do you as an organization determine how much the infringement, what it costs to the individual, and whether your interests are indeed not overridden by their interest? How do you do that? It's very difficult. It's a case-by-case basis, so even though the regulators provide guidance or can provide more guidance, which I agree, but at the end of the day, you still have to make the determination yourself as an organization whether or not this legal ground is suitable for a certain processing operation. And this is also relating to consent, which is also seen by regulators more and more, that consent or the notice and choice system like in the United States is not maybe delivering the highest level of privacy which was aspired by consent, whereas the legitimate interest might be able to help in that sense as well, even though you don't ask for consent afterwards. If you are transparent, if you provide all the information that's necessary to the data subject, if you provide a clear and good opt-out mechanism, it might be even giving more of a higher level of privacy than consent, in my view. That actually brings me to the third point I would like to make, and that's with regard to what Aurélie also said on the e-privacy directive. It's not, or regulation in the future, it's not set in stone yet, but it seems to exclude many of the legal grounds, including legitimate interest for using it for processing information for all the organizations falling within the scope of the e-privacy regulation. It's no longer only telcos, it's much more than that, but what it exactly will be is not 100% clear either. So from a practitioner's point of view, this is also, with regard to legitimate interest, one of the things that we are really looking at and trying to figure out how to deal with this possible gap that we have. There's much more to say, but I'll leave that for the panel discussion.
Super, thank you very much, Dominique. And Paul, I leave it to you.
Thanks, Aurélie, and indeed thanks to all the panelists for joining this Nymity-sponsored panel this afternoon. I'm happy to be back at Cpdp like Gabriela. It's always good to see how many interesting and high-level discussions go on here, and I'm certainly looking forward to the rest of the week. And more discussions, I guess, also on e-privacy, because it is hard now to find a panel where e-privacy is not mentioned, even though GDPR might be in the title. It is top of mind for most of the people in the room. And also, indeed, for the companies that I work with nowadays. If you ask companies what they want from legislation, the first thing that I hear is legal certainty. And that is exactly something that norm-based legislation like the GDPR is not able to offer them. And that goes with all the legal grounds for processing. Of course, when you rely upon a legal obligation, it is pretty straightforward. But when consent comes into play or legitimate interest, there is never full certainty for an organization that what they are doing will also be appreciated by a regulator, a data protection authority, or even by the courts. So if you, for example, look at consent, which is still by many, especially American companies, seen as the holy grail of data processing, in this day and age, can we indeed still provide valid consent based on the fully informed requirement? I mean, the people here in the room may still understand what is going on if a website processes your personal data, but how am I to explain that to my 80-year-old father who didn't grow up with computers? So that is a very difficult balance between fully informed consent on the one hand, informational self-determination on the other hand. And that is why I believe, and why Nymity believes, that in future years, legitimate interest should become and will become more important as a legal ground. Indeed, it is still a very difficult one, because that balancing test needs to be managed. It needs to be completed. And so you need to look at the necessity of your own interests, as was rightfully said, but also at the interest of the data subject. And that is one of the areas where we have started some research last year, looking into possibilities on maximizing also benefits to individuals, documenting the benefits to individuals of a processing operation. Also, documenting benefits to individuals won't be conclusive in your balancing test, but it will contribute to making that assessment, to find out if indeed there are overriding interests that may also help you as an organization to process the personal data. But you, the data controller that is, need to be able to explain why you have that legitimate interest, and it is certainly not a catch-all ground. How do these benefits for individuals affect the impact of the data processing on them? Which safeguards would this require? That will vary from situation to situation. For example, it could be about confidentiality and non-disclosure that could indeed help to protect the individual's rights. It could be data security. But also, can the benefits to individuals help to assess the necessity and the proportionality of the processing operation? So that is something that we will be looking more into, especially this year, where ethical data processing more than before is on the agenda, also with it being the key theme of this year's International Conference of Privacy and Data Protection Commissioners in September, hosted by the EDPS and the Bulgarian DPA here in Brussels. But also there, the benefits to individuals are part of that ethical assessment. Am I a responsible organization, being transparent in what I'm doing, and do I indeed take full responsibility for data processed in my organization? I'll leave it at that for introductions.
Super, thank you very much. I don't know if Raphaël wants to add anything or you want me to fire off something?
I always have some questions.
Go ahead.
Okay, I'm happy to ask them. So I had one question for Gabriela, because you mentioned necessity as well, one of the difficulties in using the legitimate interest ground. But my question would be that except for consent, all the other grounds require also demonstration of necessity. So do you see something more specifically difficult with this ground, or are you just necessity is equally difficult with all the other grounds that require it?
Thank you for your question. Actually, I think necessity is difficult. Well, it's very important to look at, and it must be complied with equally for all the other legal grounds. So I don't see a particular complexity linked to the legitimate interest. Necessity in general, it's not that easy to grasp. I think it would be useful for those of you that are curious about this to look at a very interesting paper published by the EDPS, the European Data Protection Supervisor, a necessity toolkit that looks quite in detail to the concept of necessity in data protection law. Just one last point here. I very recently reread the opinion of the Court of Justice of the EU in the EU-Canada PNR case. And it was very interesting to see that the court made its almost all of its findings from the conclusions when analyzing the necessity of the processing operation, because they did find that it was lawful, it did pursue public interest, public objective. It even said that it was appropriate in the sense that it was proportional. But then it went to analyze necessity, and that's where the court found that catalog of problems in that particular case.
Can I maybe jump on that also? Sorry, I know I'm a moderator, but we decided to tango. From a more technical perspective, what I'm also seeing is certainly in discussions when it comes to big data and the fact that we are moving towards more agile kinds of ways of working, and I think these two go together. If you define necessity in the beginning and data minimization partially as well, say, well, just this and nothing more, but I have processes in place from a technical perspective to collect more if required, this helps along these joint reflections as well, making sure that you balance it right for your setups, I think.
Then I had maybe also a more general point that any of the speakers can discuss upon, and it's very much related to the issues of ethics, because we've heard a lot that also we need ethical framework, that we need this ethical sentiment to determine the social interests and the benefits for the data subjects. But my question is, well, it's always difficult to make ethical decisions on behalf of others. Do you think that then this would mean, for instance, that if you want to have a sound ethical process that would involve data subjects participation, for instance, because I assume they are in the best place to determine what's in, their benefits in their best interests, and if that is the case, then doesn't this make the whole legitimate interest ground more burdensome rather than more practical?
Well, I certainly wouldn't exclude that. And also you made at the outset already the link between the ethical assessment and also the impact assessment in the DPIA, which also says that in some cases, also for a DPIA, it could be helpful to get feedback from your end users, from consumers, from the data subject. And I also believe that indeed for an ethical assessment, if you want to use legitimate interest as a legal ground, and if you do take that responsibility as an organization, for some processes that you use, it might indeed be good to get feedback from your customers or your prospective customers to see if they agree that this is in their interest, or maybe if you can't reach the customers, to at least discuss it with customer representation or bodies that we see popping up now, whether they are privacy bodies or just the consumers' rights organizations that exist. I certainly wouldn't exclude it. It's not a given, but I do think that if you are looking at documenting your assessment of legitimate interest, that it would certainly do no harm if you have also consulted other parties than just your own legal team.
Yeah, just to add to that, we also see in practice that more and more organizations are much more aware of the ethical side of data protection and privacy matters. You more often see that they want to involve the audience, they want to speak with the people that they're processing information about, just to see the sense of how they feel about the processing operation they're performing. Just an example from a few years back in the Netherlands, there was a bank that wanted to sell all the transactions details of their clients, which was perfectly legitimate if you looked at the privacy statements and what they wanted to do, but there was a public outcry that this was impossible, that it shouldn't happen. So ethics, at least in the Netherlands and in the financial sector, has gotten a lot more of attention, also with regard to the legal grounds that you use for processing information. So you can see that there is a tendency as well within the organizations themselves to look more at this and to get the feedback of their customers to know what they can do and cannot do. It links to trust as well, your image. So that's that's what I want to add.
Yeah, maybe Gabriela, I know the Future of Privacy Forum maybe has something as well they would want to share related to harms or...
Yes, indeed. I will get to that in a moment.
Okay.
But I also wanted to add something, perhaps it's a good point to make, related to ethics. And I'm thinking also of how we have to apply the principle of fairness of processing when choosing between two possible lawful grounds for processing, because it's very often that controllers can use both consent and legitimate interest, so both the letters A and F. And then when you are making that choice, the question is, what would be the fair choice? How can you ensure fair processing better? So I think it should be taken into account when the choice is made. I do not know how, but I think it's something to take into account. And to go to the excellent work of my colleagues, they actually published, we published a framework where we identified harms in the algorithmic decision-making type of processing, and we qualified potential possible harms, and I think that exercise is very useful both for data protection impact assessments and for assessing whether we can use the legitimate interest as a lawful ground.
Yeah, I think that slowly but surely, when it comes to legitimate interest, we're starting to see different bases or different documents we can use to start building a way of working around this. I don't know if there's any other comments. Leonardo, do you want to build on something here?
From where I stand, I see this debate like logical evolution of the data protection field over the years, because at the very beginning, when the whole thing started, everything was based on law determination, prior checks, authorizations by data protection authorities. And as technology evolved, everything started to become unsustainable. So I think the law has been evolving to the reality of new technologies that many of them are clearly beneficial for the individuals, and therefore this concept of legitimate interest emerged, and now the new broader context of coupling legitimate interest with data ethics is little by little evolving, and is in the same direction of accompanying the evolution of technology, but without really compromising the foundations of data protection. Critics often say, how can you continue defending your data protection laws in the face of big data? And we repeatedly say, we can and we do, because all these things are perfectly applicable to big data scenarios, only that we ask data controllers to be accountable what they do, embrace the principles of accountability, privacy by default, and an ethical approach to processing. And if you do that, you're perfectly okay from the data protection point of view. This is the flexible way we endorse from the EDPS, and this is more or less the ethical sentiment that we're trying to put into the discussion, but always remembering that this does not mean a blank check or an open door for doing whatever you want, because that simply means that if you have a strong case that you can, as rightly pointed out, properly document, then it should be all right, and you're in safe grounds, and then the legislation is not so uncertain anymore, because you're on solid ground to do what your company needs to do and probably is beneficial for the individuals.
Yeah, I think that is also one of maybe the changes that we'll see under GDPR with the new accountability requirement, that organizations are indeed obliged to properly document everything they're doing in privacy and data protection, not just their legitimate interest assessment. So far in many countries and by many organizations, legitimate interest was indeed used as a sort of catch-all clause for all the data processing. They couldn't fit in any of the other grounds. Whereas from now on, in any case, you need to be able to demonstrate compliance with every provision, so including your legal grounds assessment. Make sure that you can reconstruct your arguments, why you have made certain decisions, why you how you did the balancing test, and why indeed the interest of the individual can be overridden in your specific situation by the interests of the organization. So yeah, that DPAs will likely come to ask your records on that as well if you want to rely on legitimate interest.
Maybe also to build on top of that, again, from a more technical perspective, it's my general nightmare how you structure that information. And José Luis Piñar, which is a former DPA in Spain, also talked about moving towards a model of responsible management of data instead of just managing it in a proactive way before that. So I think that will be interesting also to see how this is going to evolve. And maybe discussions about how accountability is set up in terms of documentation, or how, if we talk about more specifically about what does a balancing test look like. In the previous panel I heard, Simon, I'm sorry to be pointing towards you as well, but discussions around this idea of privacy engineering, and that it should be about engineering privacy for the entire company. So I think when we're talking about also documenting one way or another, it's not only one specific silo where the contracts or the legal documents are being kept, but also to make sure that this is an inclusive way of working, that many people are involved within these balancing tests. Any thoughts on that?
Actually, maybe I can also add something on top of what you just said, because so now we've heard a lot about this idea that legitimate interest goes hand in hand with different models of, let's say, regulation, and how data controllers are increasingly accountable. And I mean, what this triggers in my thought is the idea that, for instance, going back to the example of the DPIA, it's a great example of how we, shifted from the prior notifications to more responsibility for the data controllers. But that goes along with Article 36, which is about the idea of prior consultations in case of high risk that cannot be mitigated. So I'm just here, launching some ideas, but given the difficulties that we have with determining whether the legitimate ground can be relied upon, do the panelists think that having this kind of similar mechanism whereby data controllers would consult with data protection authorities in case they have doubts, does this make sense, that this helps render the ground more workable for data controllers?
Okay, I'll try to give an answer. Before I started with Considerati, I worked for the Dutch Data Protection Authority, so I try to look from both sides to this question. From organizations' perspective, there might be many who would like to have people thinking with them on how to approach certain dilemmas, because sometimes it's very difficult, and most organizations just want to do it right, but they don't know how. And that's when it's really easy if there would be somebody at the Data Protection Authority who could help you, a partner who you can discuss these things with without having the fear of being fined 2 years later or a month later or whatever. And that's the difficulty for the Data Protection Authority as well. You always hear them say they have limited resources, but there are limited resources because there are thousands, if not millions, of organizations in the European Union that would really like to have discussions with the regulator on these things without having to have the fear of being fined or sanctioned for whatever they're doing. So I think it's from both sides that there is willingness, that they really want to be open, that there's always also the problem of the roles that they have. A regulator has the role of regulating, of monitoring, of when things go wrong, that they really do act, and that they need to be independent enough to be able to do so. And at the same time, organizations also must take the responsibility of making decisions. And maybe sometimes they might not be right, but at least if you've documented it, why you've taken such a decision, I'm sure that a negotiation with the Data Protection Authority might not lead to a 20 million fine just the next day. So yes, it would be good. I think from both sides they really want to, but I find it in practice, I think it will be really difficult to make it really work.
Yeah, I would agree with that. I mean, we're former colleagues, for full disclosure, at the Dutch DPA, so I tend to agree with that assessment, also because of the independence of the data protection authorities. It will be very hard for them to come down on an organization to enforce the law if at front they had said, oh no, but this processing is indeed fine, where later on it appears it's not. But also in those situations where as an organization you want to consult with the DPA, as Aurélie rightly stated earlier, we are in an age of agile development, organizations working much faster in developing their products, their services, changes being announced every 2 weeks, every 4 weeks, every 6 weeks. how do you want to make sure that you keep the consent of your data subjects valid? By asking them every 2 weeks, do you consent with this new feature that we've introduced that you may not fully understand yet, but which we are sure that will be good for you and that you will like it 2 years down the road? Also for those situations, legitimate interest might be a good reason, might be a good legal ground where you can do that balancing test and update your balancing test like you update your data protection impact assessments. And maybe not consult with the DPA, but at least be transparent about it. Be clear about what you are doing and keeping your documentation up to date. And what that documentation should be, it can be anything. It could be internal memos on from the legal department or the DPO giving the pros and cons of the argument. It could be the minutes of a meeting where something is decided. It could be your policies and procedures that you use to limit the risks to the data subject, to the rights and freedoms that they have. And that full combination of documentation could be shown to a data protection authority if they come to call. And then it is up to the data controller to explain why they believe that they are right. In the end, the burden of proof will always be on the data controller, whether they can consult with a third party or not.
Maybe related to that position of the DPAs as well, an example from a couple of years back in another sector, when launching a website for a bank here in Belgium, I was asked to clear that with legal at some point. There wasn't a discussion about privacy or things like that, but so I was asked to basically get down to the other building in a very stuffy corner somewhere, working in the digital area at that moment, and I asked the questions to the lawyer to say, what do we need to do to make sure that you give it okay? And the gentleman behind the leather chair and the big desks with paper piles told me, well, as long as the banking commission is fine with what you're doing, I have no problems with that. And so basically that's what we did. We invited the banking commission and we explained what we did. I did not want them to give an okay or yes, a thumbs up or things like that, but give me indications of how can I improve. What is wrong? What don't you like, or where might there be a problem? So it really depends how you see, I think, the angle related to what you need, or how do you see supervisory authorities helping in building this together in terms of GDPR, making sure that we find that balance right between what companies want, but also what data subjects expect from companies and how they would handle their data. So I think we're maybe through, unless Raphaël has any more kind of discussions, maybe open it up to the floor. Any comments, questions you would like to share? We still have half an hour, so I wanted to make sure to share with the audience as well.
Thank you to give me the opportunity to ask some questions. I'm Willem de Beukelaar from the Belgium Data Protection Authority. The GDPR contains also Article 25, privacy by default, privacy by design. I think that you have to combine in the balancing test also this, I will not say new, but practically new obligations. And I think here I can join Leonardo when he said it's also an ethical question, but it's also a question of how, in this balancing test, can I introduce the obligation to have to provide privacy by design and by default. If I have to do that on a proper way by default, I have to look what if there are no other grounds who give more protection, who give more rights to the citizen. What are you thinking about that?
Take another question before we start answering? Yes. Thank you. Yep. Yes?
Nicholas Martin from Fraunhofer Museum Karlsruhe. This question is in particular to Paul, but not only. So we heard about how difficult it is to use the legitimate interest ground in a really legally solid way. But to your knowledge, or that of any other members of the panel, have there been any cases or do they see it more as one further cause of legal uncertainty, hampering them or stopping them from undertaking investments or developing products?
Okay, thank you. And we'll maybe go towards Simon.
Thank you, Simon Hania, TomTom. I wanted to ask the panel to reflect a bit on the following, and it relates to fairness, ethics, and harm. So, these days, what a lot of companies do is they use data to train artificial intelligence. Before that trained AI gets applied to individuals. So this is about training AI. One of the things to arrive at high quality trained AI is to have high quality data input. And one thing you should avoid is having biased data, a self-selecting sample. So there could be a situation in which when you ask consent, you will get consent from those who want to participate, which excludes those who may be not willing to participate because, for instance, they may be speeding. That could arrive in low quality AI. And then the question is, if consent, as the EDPS now states, has precedence, can I still use legitimate interest for that in the interest of arriving at higher quality and maybe even fairer results when I subsequently, in the second stage of processing, start to apply the trained AI to individuals that have bought into a service, so for a contract?
Okay, thank you. So we have 3 questions here, maybe starting with the first one, privacy by design and by default. Anyone?
I can take that one, and I think it's an excellent point indeed. With Article 25 and data protection by design, and as you know, in this idea of having a balancing test, so you look at you identify and look at the legitimate interest of the controller, and then you identify possible conflicting rights, interests, freedoms of the individual. It probably most often than not, the rights of the individual will weigh more than the legitimate interest of the controller. What you have to do afterwards is to think of safeguards, think of technical and organizational measures to put in place so that the balance is rebalanced, let's say, and then goes towards the legitimate interest of the controller. I think having a very solid data protection by design compliant processing activity would certainly help with the rebalancing there. And on another hand, in a way, I'm looking at this as if it's in a circle, because if we look at Article 25, paragraph 1, more or less it requires towards the end. So it really requires to put in place technical and organizational measures in order to meet the requirements of this regulation. So it's a very, very broad obligation, and having a legal, a valid lawful ground for processing is one of the requirements of this regulation, actually, of the GDPR. So then I think they kind of support each other, having a valid lawful ground in the legitimate interest, and then using Article 25 for that, and then using Article 25 to make sure you have the valid ground.
The rebalancing. Okay, thank you. Maybe about moving on to the next question, or you?
Yeah, happy to answer that, and that also builds a bit on the question that Willem asked on privacy by design and privacy by default. There is indeed a case that I am aware of, and I'm sure that there are more which I'm not aware of. But last October, the Dutch EPA ruled against ICANN on the Whois register. And there they said that ICANN cannot publicly or put public on their website the names and contact details of the registrars of any website, because it is not necessary again for the execution of a contract. It is not possible within a legitimate interest because there are less impacting alternatives available, and consent would not be valid because it would not be freely given. That was assessed under current law, but also under the GDPR already, to make sure that ICANN couldn't claim, oh no, but under the GDPR it would be legal, so don't start enforcement action because legalization is in sight. That was already ruled out from the investigation. And that also shows that indeed, if there are measures that you can take to secure privacy by design, privacy by default, that you should do that, and that should be part of the legitimate interest assessment. So I fully agree with Willem, and basically the DPA has said it on legitimate interest. No, this cannot be used because the purpose of this processing can be achieved with less impacting means, for example, by giving shared access to the WHOIS data to those who should have access to that information.
Okay, I think that I don't agree with the appreciation that this legal ground for processing is not solid enough, is not good enough. I do not agree. I think it has been said by previous speakers that the GDPR is very clear about it, that it's not prescriptive. It says any legitimate processing is okay, so it's really open. And what it is not is a shortcut. It is very solid, but companies need to do their homework. They need to go and do the necessary to ensure compliance. And this is actually an evolution in terms of data protection law, because actually the GDPR has not been done overnight. It's the response of the European legislator to years of debate and criticism. And one of the things that was always said, in particular from other latitudes, was that our legislation was not flexible enough, that couldn't cope with technological developments. We did what we were required to do, and we have now given companies ample possibilities to do ample processing of personal data, but at the same time we have put very clear, dark and white in the law that they must be accountable for what they do, that they need to use technology to serve humankind and not humankind adapting to technology. And we have said that they have to start by design, by the engineer floor and everything. So it is a very solid legal ground that can be used, and I don't think anybody will risk any problems with the DPAs if they do it seriously, but it cannot be understood as a shortcut or as an open door to legitimize any kind of processing by the company.
Okay, so obviously legitimate interest through accountability is evolving and becoming something we really need to work on moving forward. Maybe moving on to the third question that came out of Simon, thank you for that. Being based in statistics and econometrics, basically initially, obviously big data brings along, I think, this idea that we are not verifying the representativity of populations anymore when we undergo statistical analysis, which is a big change from the research that's done, for example, in certain other fields using data. So I totally agree with what you're saying, and having said that, I have issues with data science people when talking about you have to make sure that you have no biases inside your population. So it would be interesting to see what practices, recommendations we might find within the GDPR or ideas moving forward to make sure that indeed these biases are not reflecting moving forward with artificial intelligence and collecting data. Any thoughts?
Well, I also totally agree with both of you. Artificial intelligence is something that it's not particularly new, but it's relatively new to the privacy discussions. And we also increasingly see this with the clients that we have, organizations that ask for our help. It's always difficult. It's a very difficult idea of and grasping what exactly the artificial intelligence is doing, what information it requires, what legal ground do you use for this? Is consent the only legal ground possible, or is legitimate interest with the right measures, guarantees, etc. also possible? I think this would be a brand new panel actually if we wanted to discuss all these kind of things, and I completely agree that it's a very important thing that we need to discuss more and think more about, because I agree sometimes the samples only with consent might not be enough to grasp the fruits that are possible to be grasped by artificial intelligence. And how do we do that? How can we make use of everything that's offered by the new techniques without interfering too much with the privacy, and also without asking people for things that they don't understand? Because consent is obviously very difficult, especially in an AI context, to explain what is actually happening and what the consequences might be. So I would agree that more legal grounds would help, but then of course we also have to take into account that all the safeguards need to be taken. You cannot use it as a blank check, which I also understand from a regulator's perspective. So that makes the balancing test and the necessity test a really important thing to discuss with all of us, I think.
Yeah, I just want to, it's excellent because this is exactly the point I wanted to make, that the main clash I see between data protection and AI and having high quality AI, it's actually on necessity and on data minimization, the data minimization principle. Because you have, so you have the data minimization principle that asks to use as little data, as little small amount of data as possible to achieve your result, and on the other hand, you have the AI that works on as much data as possible to be collected. So I think that's the biggest clash there. And then it would be very interesting to look at this balancing test, and especially, well, the necessity of using the data that goes into the AI magic box. And how do you, I mean, you have to prove that all the data items you use are necessary to achieve the purpose, the interest, the purpose of the processing. And also, well, the Court of Justice, whenever they analyze necessity, they never analyze necessity, they analyze strict necessity, if you look at the wording. So that's, to me, it's even a more restrictive criterion. So a lot of conversation to go there.
Wouldn't there be also an argument to be made for purpose alignments? Because the difference between I collect data for that specific purpose, but I actually anonymize, hash, whatever you want to do with it, and put it inside my machine learning buckets, is not exactly the same thing. So which comes back also to the need for transparency related to data uses.
Yeah, that's a great point. Yep, I don't know how to. I agree with that. I just wanted to mention about transparency. It's very important to note that even if you use Article 6.1f, so even if you use legitimate interest, be aware that you still have to comply with the notice requirements. So a lot of people are running from, well, people, not controllers, are running from consent because it needs to be informed. It's one of the reasons. But the fact is, you have to provide exactly the same information when you're using legitimate interest. You have to provide notice to the data subject as well and be transparent.
It's true, you still have to provide notice, but at least one burden that you don't have if you use legitimate interest, you don't have to verify if the data subject indeed has understood what you are providing as notice. That doesn't mean that if the DPA comes to check your notice that it can be unclear as ink, but if you provide clear and notice in a language that the data subject should be able to understand, if he or she then still is not able because they just don't grasp the technical concept behind simple data processing or complicated data processing, even though you did your best to explain it, then still your legitimate interest could be valid, whereas your consent would not be. Because if they haven't understood, then that would be a problem. I wanted to follow up actually on the further processing that was discussed also for AI. Of course, also there you need not only to look at the interest of the organization, but also at what does it mean for the data subject. Would this surprise the data subject? If so, if there are surprises, don't do it. Also here, you should stick to the motto of, I believe it was the Holiday Inn, the only surprise are no surprises. That also very much applies to data processing operations and for further use. But also if you use legitimate interest, make sure that indeed a data subject can safely assume, oh yeah, no, but that makes sense that they process my personal data, that it is this way, and maybe that I don't consent for that.
Interestingly, you didn't touch upon withdrawal of consent as well, which makes the discussion also slightly more complicated for certain setups.
Well, yes and no. I mean, withdrawal of consent is, of course, important. At the same time, you also have the right to object for legitimate interest, which at least was designed to have a similar aim as the withdrawal of consent. So it isn't as absolute as the withdrawal of consent, because if you put forward an objection request to any organization, a rebalancing needs to be done, but then not for data subjects in general, but for you as a specific individual, which could have a different outcome. But also there, if you have properly documented all your benefits from the outset, that will also help you to do the rebalancing and maybe be able to show that indeed the legitimate interest still stands and that the objection fails. Whereas withdrawal of consent always has to be respected.
Maybe, yes, we'll take again 3 questions and try to address them. Yes, please. Okay, we'll relist the different things we've already mentioned. Thank you. Anything else? Yes, please.
Thank you. According to recital 47 of the GDPR, you can use legitimate interest for direct marketing purposes. Do you think that in practical terms, is it feasible to assess necessity and to conduct this balancing test in this case? And how can a data controller choose between consent and legitimate interest for direct marketing purposes? Thank you.
Okay. Recital 47 was inevitable. Yes, thank you. Anybody else? Okay, maybe take the last one. Who wants? We'll go like this? Yeah.
I can, like, this goes exactly to my first point that I made at the beginning of the panel, that it's very easy to identify a legitimate interest. And direct marketing is one of those legitimate interests. But this does not mean you can automatically use legitimate interest for direct marketing processing. You still have to prove necessity, you still have to make this balancing exercise, you have to bring safeguards into the balancing test. Yes, legitimate interest can be used, certainly, for direct marketing, but only after this solid analysis in order for it to be valid and to stand the test of a DPA. And then again, you go to the point of thinking of every data item that you use and how that is directly linked, it goes directly to the result, to your purpose.
For direct marketing, it's fairly the same now in the Netherlands, that for direct marketing purpose you can use the legitimate interest, but there's this one very important condition, and it's that there should be a client relationship, and the way that they've defined a client relationship is that there must be a financial transaction. This is especially with a view to the future, something that we are looking forward to more guidance on this, is whether that remains the same, whether financial transaction still is one of the core criteria for determining whether direct marketing can be done on the basis of the legitimate interest. Because most of the many services online especially are no longer with paid services in the sense of money. You pay differently, or it's a free service, as they call it. And then it's very hard to define at the moment whether there is indeed a client relationship which allows you to base the processing operation on direct marketing. So more guidance on this would be helpful. We're still looking at it. We're still advising on the strict sense, because you never know. But at the same time, reality is moving on. So I sometimes think also the interpretation of the law should be moving on.
Okay. Maybe passing through before I pass the ball on the left. I think we're talking about the last sentence of Restol 47. There's the previous last sentence of Restol 47, which doesn't use the same tense of the verb. So it talks about fraud, which there is no discussion about it. And then the last sentence is, it may be used for direct marketing. So just slight difference. I'm not a lawyer, but I like that difference.
And that is certainly an impactful difference that the European courts will chew over in the coming years. Another thing is that also here we need to take a careful look at the relation between the GDPR and the future e-privacy regulation, because direct marketing online likely will always require consent. Whereas then it is implied that the direct marketing which you could use a legitimate interest for would then be offline marketing only. Or will it? That is something also that hopefully the legislator will be able to answer still before the e-privacy regulation comes to the EU publication, the official journal. On ethics and ethics frameworks, that is an ongoing discussion. At Nymity, we are doing some research indeed on maximizing benefits to individuals, and there is an accompanying framework with some benefits already included that is available on our website. I also know that the Information Accountability Foundation has published some papers on ethical data processing, for example, for the Office of the Privacy Commissioner of Canada, and there are more documents. I think also the FPF is doing some work on ethics.
Yeah, we're actually, well, the framework I already mentioned. Thanks, Aurélie, for that. And you'll see there, it's really useful, and it's just, it's really a one-pager. It's a map and a table. It's very useful. And then also we've partnered with the Nymity to work specifically on legitimate interest, and we are actually looking at existing cases, decisions of the DPAs, national case law in the EU where legitimate interest was a core issue. We want to summarize that in order to make it useful for organizations, and hopefully by the end of February it will be available.
Okay, and then last but not least, the shifts and values white paper that is coming out by the EDPS through the ethics advisory group, which is going to be released tomorrow, and we'll be talking about that on a panel as well.
Yeah, that's exactly what I wanted to say. That, as has been said, this is a very interesting ongoing debate, which is the meaning of data ethics, which should be these ethical frameworks. So tomorrow, I think, at what time? 5? There is this panel where the ethics advisory group, 3, will present the results of 2 years' work on this issue. Very, very intense research conducted, and sometimes very difficult to understand, to be honest, because it's very forward-looking, very deep, and we will also use this topic for the international conference in October here in Brussels, where we will put together not only Europeans but people all around the world to find some meaning to this new concept, which is, I think it's very promising. It's very visionary from our supervisor, Giovanni Buttarelli, and we will now to launch a debate to start to put some meaning and examples to this visionary concept.
So yeah, I think we have to wrap up. So thank you everyone for joining us on this panel on legitimate interests. And well, have a great continuation of the conference.